Welcome back. The discussion today is about free speech and its limits. When you see the American flag in flames, would you assume that that is illegal under U.S. law or legal? I bet you would say that it's illegal, but guess what? It's legal. It's actually protected by the U.S. Supreme Court. The Supreme Court actually ruled on a specific case pertaining to flag burning. It was in 1989. Pretty controversial, because some people believe that there's no offense more heinous than burning the symbol of our country. The Supreme Court ruled, however, that this was not only a protected form of free speech, but it was slightly elevated among other forms of free speech because it was a commentary on the United States government and its policies, or at least perceived to be as much, and therefore it was of heightened interest in terms of free speech. Now I'll ask you the same question about cross burning. The burning of a cross out in the field, would that be considered illegal as well? In 2003, the Supreme Court similarly agreed that it was not illegal, that it was an expression of opinion and therefore protected. Pretty surprising, isn't it? Well, if you understand the First Amendment and you understand the way law has developed surrounding the First Amendment in our country, it's not that surprising. Now, if we were in another country where the state could tell people how to comport themselves around symbols like the American flag or the cross, that would be different. But fortunately, we're in a country that allows people to comport themselves around a symbol the way they wish. I guess you could be convicted of such things as arson or vandalism if you burn someone else's American flag. But if it happened to be your own American flag and you didn't harm anybody in the process, then the Supreme Court said that's the right that you're entitled to. I guess one could be charged with inciting a riot if in fact that happened and a riot ensued, but the mere act of burning the flag unto itself is not. So yeah, this is a great consideration to think about free speech in America. Now let's talk about if we have free speech of that dimension, what can't we say in a free country? Let me introduce you to a concept that everybody who studies the media ought to appreciate, and that is the whole issue of libel or slander. The definition of libel is something that is false, defamatory, and causes damage to someone. It's evolved over the years through case law and rulings in the Supreme Court to where there are a lot of protections for the press against being sued for libel. The most important case of all is the New York Times versus Sullivan ruling way back in the 1960s. And that was a case in which an ad was placed in the New York Times that contained some claims about Southern government and Southern officials who were oppressing race minorities. One individual, one county official sued the New York Times and initially won a case for libel, saying that he had been defamed by the advertisement in the New York Times. Ultimately, the Supreme Court ruled that the New York Times was protected because all the people who were involved were public figures, elected officials, and the court ruled that unless even if something was false and malicious, one had to demonstrate, or false, one had to demonstrate what we call actual malice to obtain a libel judgment. Yeah, the The libel laws are very important for people who study free speech in our country because they pertain mostly to publications and news organizations. If there's a libel case and something is said that is false and damaging to someone, it's most likely that an entity like a publication would get sued because that's where the money is. Now, I was editor of a small daily newspaper for 6 years in southern Colorado. We were sued twice for libel. Neither of the instances had anything to do with what I was doing. Amazingly, one of them was about a classified ad that someone had purchased that made some claims that were defamatory. A classified ad manager should have been more alert to the whole issue of libel. The other time we were sued for libel involved a letter to the editor where someone made a claim about a police officer who had treated an animal cruelly. Turned out to be he falsely identified, and we had to settle out of court. Often libel cases develop out of news reporting when errors happen. Someone is identified incorrectly as having committed a crime or something, and that's where often people sue for libel and can get judgments against newspapers. It's a very dangerous situation. Now, what is the public figure standard? Actually, it applies to two different issues in libel and also in invasion of privacy. That's another press issue. Public figure means that if you've placed yourself out in the public, say you're an elected official or a celebrity, the standard is much higher for libel because you have invited public scrutiny and possibly criticism. Actual malice is one issue that pops up if there's a false claim, and if one is a public figure and a false claim is made about that person, then sometimes the standard is that malice must be demonstrated that the public figure was libeled. Otherwise, it could just be an error in a person, and if public figures could sue over any error that appeared in print relative to them that might be defamatory, that would really stifle the examination of public figures. However, if you're not a public figure, sometimes all it takes is the actual misidentification or something that's printed, something that is false. The key ruling that you'll read about in the book is about the defense of opinion. In the case that the book discusses, it was a suit against the publisher of Hustler magazine. Hustler had printed a spoof about a religious figure, and he sued. The Supreme Court ruled that opinion is something that cannot be defamatory or cannot be libelous, which is a good thing for satirists and all sorts of people. If you're out there in the public, you can make fun of public figures without worrying about being sued for libel. Paired with these, of course, is what I mentioned earlier, invasion of privacy. Now, a person who does not place him or herself in the public eye, has a lot more leeway to sue a press entity if that person's privacy has been invaded. And that's a very important concept of press law, that if you were to get into the media in a career, you would need to understand the whole principle of invasion of privacy. Who does not, who does the press have the right to put just anybody's picture in the newspaper without permission? Not everyone, and certainly cannot not something that might be construed as defamatory. When you see the word prior restraint, I think what you probably need to remember is the whole Pentagon Papers um, issue or ruling that came from the U.S. Supreme Court. Um, does the government have the authority to prevent um, press entities from publishing something that they have in their possession? Pentagon Papers were documents that were um, taken away from secure location relative to uh, how the Vietnam War was prosecuted, and it came into the possession of the New York Times. Um, the U.S. government tried to stop the New York Times from publishing the Pentagon Papers. They went ahead and did it anyway, and the U.S. Supreme Court ruled that the Times was entitled to um, print material that it had obtained. Of course, the U.S. government can block the release of highly um, sensitive material, but once it gets out, it's out there, and the First Amendment protects it. One more thing to keep in mind is this issue of copyright infringement. It's not the same thing as prior state in any fashion. It has to do with commercial endeavors or stuff that's printed material or published material that has a copyright on it. Understand that once copyright has been infringed, if a media entity uses copyrighted material, does not give credit, and makes money off of it. Now, since copyright material is floating all over the place in the form of books and newspapers and all that, generally the standard is that if you identify the source and you give proper credit to the source, it's going to be fine. But if you use copyrighted material without identifying the source and it's used in a commercial vein, you can be sued for copyright infringement. Back to the issue of the flag burning and the cross burning. The United States has an amazingly flexible approach to speech issues. It's sort of amazing that political forces have never been able to really clamp down on these types of things. For instance, in Congress, invariably there's going to be an effort by certain members of Congress to try and pass a constitutional amendment to prohibit flag burning. Fortunately, that's never got off the ground because most people come to understand that it's not the government's position, not the government's job to be telling people how to behave around symbols. And that's all a flag is. It's just a symbol, whether it's on cloth or paper or whatever. Some people will say, well, don't you support the flag and don't you oppose flag burners? That's not the point. The point is, what is symbolic speech? And how can the government tell people how they should act around symbols? So to that effect, as someone who was involved in free speech professionally, I'll say, God bless America. I'm not one about to burn a flag or a cross, but I appreciate the fact that our highest courts have said that the government is in no position to tell people how to deal with either of those symbols. Good for all of us. Talk to you later.